Welcome to Motivation at Hand, Ma. To know is to know how. Continued, Case 1:23 cr-00257-TSC Document 1 filed August 1, 2023. The defendant's knowledge of the falsity of his election fraud claims. 12. The defendant widely disseminated his false claims of election fraud for months, despite the fact that he knew, and in many cases had been informed directly, that they were not true. The defendant's knowingly false statements were integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' right to vote and have their votes counted. He made these knowingly false claims throughout the post-election time period, including those below that he made immediately before the attack on the Capitol. On January 6. A. The defendant insinuated that more than 10,000 dead voters had voted in Georgia. Just 4 days earlier, Georgia's Secretary of State had explained to the defendant that this was false. B. The defendant asserted that there had been 205,000 more votes than voters in Pennsylvania. The defendant's acting Attorney General and acting Deputy Attorney General had explained to him that this was false. C. The defendant said that there had been a suspicious vote dump in Detroit, Michigan. The defendant's Attorney General had explained to the defendant that this was false, and the defendant's allies in the Michigan State Legislature. The Speaker of the House of Representatives and Majority Leader of the Senate had publicly announced that there was no evidence of substantial fraud in the state. D. The defendant claimed that there had been tens of thousands of double votes and other fraud in Nevada. The Nevada Secretary of State had previously rebutted the defendant's fraud claims by publicly posting a facts versus myths document explaining that Nevada judges had reviewed and rejected them, and the Nevada Supreme Court had rendered a decision denying such claims. E. The defendant said that more than 30,000 non-citizens had voted in Arizona. The defendant's own campaign manager had explained to him that such claims were false, and the Speaker of the Arizona House of Representatives, who had supported the defendant in the election, had issued a public statement that there was no evidence of substantial fraud in Arizona. F. The defendant asserted that voting machines in various contested states had switched votes from the defendant to Biden. The defendant's Attorney General, acting Attorney General, and acting Deputy Attorney General all had explained to him that this was false, and numerous recounts and audits had confirmed the accuracy of voting machines. The criminal agreement enacts to effect the object of the conspiracy. The defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. 13. Shortly after Election Day, which fell on November 3, 2020, the defendant launched his criminal scheme. On November 13, the defendant's campaign attorneys conceded in court that he had lost the vote count in the state of Arizona, meaning, based on the assessment the defendant's campaign advisors had given him just a week earlier, the defendant had lost the election. So the next day, the defendant turned to co-conspirator 1, whom he announced would spearhead his efforts going forward to challenge the election results. From that point on, the defendant and his co-conspirators executed a strategy to use knowing deceit in the targeted states to impair, obstruct, and defeat the federal government function, including as described below. Arizona. 14. On November 13, 2020, the defendant had a conversation with his campaign manager, who informed him that a claim that had been circulating, that a substantial number of non-citizens had voted in Arizona, was false. 15. On November 22, 8 days before Arizona's governor certified the ascertainment of the state's legitimate electors based on the popular vote, the defendant and co-conspirator 1 called the Speaker of the Arizona House of Representatives and made knowingly false claims of election fraud aimed at interfering with the ascertainment of and voting by Arizona's electors, as follows. A. The defendant and co-conspirator falsely asserted, among other things, that a substantial number of non-citizens, non-residents, and dead people had voted fraudulently in Arizona. The Arizona House Speaker asked co-conspirator 1 for evidence of the claims, which co-conspirator 1 did not have, but claimed he would provide. Co-conspirator never did so. B. The defendant and co-conspirator 1 asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud. The Arizona House Speaker refused, stating that doing so would require a 2/3 vote of its members, and he would not allow it without actual evidence of fraud. C. The defendant and co-conspirator 1 asked the Arizona House Speaker to use the legislature to circumvent the process by which legitimate electors would be ascertained for Biden based on the popular vote, and replace those electors with a new slate for the defendant. The Arizona House Speaker refused, responding that the suggestion was beyond anything he had ever heard or thought of as something within his authority. 16. On December 1, co-conspirator 1 met with the Arizona House Speaker. When the Arizona House Speaker again asked co-conspirator 1 for evidence of the outcome-determinative election fraud he and the defendant had been claiming, co-conspirator responded with words to the effect of, "We don't have the evidence, but we have lots of theories." 17. On December 4, the Arizona House Speaker issued a public statement that said, in part, "No election is perfect, and if there were evidence of illegal votes or an improper count, then Arizona law provides a process to contest the election, a lawsuit under state law. But the law does not authorize the legislature to reverse the results of an election. As a conservative Republican, I don't like the results of the presidential election. I voted for President Trump and worked hard to re-elect him. But I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. I and my fellow legislators swore an oath to support the U.S. Constitution and the Constitution and laws of the state of Arizona. It would violate that oath, the basic principles of Republican government, and the rule of law if we attempted to nullify the people's vote based on unsupported theories of fraud. Under the laws that we wrote and voted upon, Arizona voters choose who wins, and our system requires that their choice be respected." 18. On the morning of January 4, 2021, co-conspirator 2 called the Arizona House Speaker to urge him to use a majority of the legislature to decertify the state's legitimate electors. Arizona's validly ascertained electors had voted 3 weeks earlier and sent their votes to Congress, which was scheduled to count those votes in Biden's favor in just 2 days' time at the January 6 certification proceeding. When the Arizona House Speaker explained that state investigations had uncovered no evidence of substantial fraud in the state, co-conspirator 2 conceded that he didn't know enough about facts on the ground in Arizona, but nonetheless told the Arizona House Speaker to decertify and let the courts sort it out. The Arizona House Speaker refused, stating that he would not play with the oath he had taken to uphold the United States Constitution and Arizona law. 19. On January 6, the defendant publicly repeated the knowingly false claim that 36,000 non-citizens had voted in Arizona, Georgia. 20. On November 16, 2020, on the defendant's behalf, his executive assistant sent co-conspirator 3 and others a document containing bullet points critical of a certain voting machine company, writing, "See attached, please include as is, or almost as is, in lawsuit." Co-conspirator 3 responded 9 minutes later, writing, "IT must go in all suits in GA and PA immediately with a fraud claim that requires the entire election to be set aside in those states and machines impounded for nonpartisan professional inspection." On November 25, co-conspirator 3 filed a lawsuit against the governor of Georgia falsely alleging massive election fraud accomplished through the voting machine company's election software and hardware. Before the lawsuit was even filed, the defendant retweeted a post promoting it. The defendant did this despite the fact that when he had discussed co-conspirator 3's far-fetched public claims regarding the voting machine company in private with advisors, the defendant had conceded that they were unsupported and that co-conspirator 3 sounded crazy. Co-conspirator 3's Georgia lawsuit was dismissed on December 7. 21. On December 3, co-conspirator 1 orchestrated a presentation to a judiciary subcommittee of the Georgia State Senate, with the intention of misleading state senators into blocking the ascertainment of legitimate electors. During the presentation, an agent of the defendant and co-conspirator 1 falsely claimed that more than 10,000 dead people voted in Georgia. That afternoon, a senior advisor to the defendant told the defendant's chief of staff through text messages, "Just an FYI." A campaign lawyer and his team verified that the 10K plus supposed dead people voting in GA is not accurate. It was alleged in co-conspirator 1's hearing today. The senior advisor clarified that he believed that the actual number was 12. Another agent of the defendant and co-conspirator 1 played a misleading excerpt of a video recording of ballot counting at State Farm Arena in Atlanta and insinuated that it showed election workers counting suitcases of illegal ballots. C. Co-conspirator 2 encouraged the legislators to decertify the state's legitimate electors based on false allegations of election fraud. 22. Also on December 3, the defendant issued a tweet amplifying the knowingly false claims made in co-conspirator 1's presentation in Georgia. Wow. Blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Plenty more coming, but this alone leads to an easy win of the state. 23. On December 4, the Georgia Secretary of State's chief operating officer debunked the claims made at co-conspirator 1's presentation the previous day, issuing a tweet stating, "The 90 seconds video of election workers at State Farm Arena, purporting to show fraud was watched in its entirety, hours, by Atgasikoff state investigators. Shows normal ballot processing." Here is the fact check on it. On December 7, he reiterated during a press conference that the claim that there had been misconduct at State Farm Arena was false. 24. On December 8, the defendant called the Georgia Attorney General to pressure him to support an election lawsuit filed in the Supreme Court by another state's Attorney General. The Georgia Attorney General told the defendant that officials had investigated various claims of election fraud in the state and were not seeing evidence to support them. 25. Also on December 8, a senior campaign advisor, who spoke with the defendant on a daily basis and had informed him on multiple occasions that various fraud claims were untrue, expressed frustration that many of co-conspirator 1 and his legal team's claims could not be substantiated. As early as mid-November, for instance, the senior campaign advisor had informed the defendant that his claims of a large number of dead voters in Georgia were untrue. With respect to the persistent false claim regarding State Farm Arena, on December 8, the senior campaign advisor wrote in an email, "When our research and campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 0 to 32 on our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy shit beamed down from the mothership." 26. On December 10, 4 days before Biden's validly ascertained electors were scheduled to cast votes and sent them to Congress, co-conspirator 1 appeared at a hearing before the Georgia House of Representatives Government Affairs Committee. Co-conspirator 1 played the State Farm Arena video again, and falsely claimed that it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then, he cited 2 election workers by name, baselessly accused them of quite obviously surreptitiously passing around USB ports as if they are vials of heroin or cocaine, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. Thereafter, the 2 election workers received numerous death threats. Co-conspirator 1 played the State Farm Arena video again, and falsely claimed that it showed voter fraud right in front of people's eyes and was the tip of the iceberg. Then, he cited 2 election workers by name, baselessly accused them of quite obviously surreptitiously passing around USB ports as if they are vials of heroin or cocaine, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. Thereafter, the 2 election workers received numerous death threats. 27. On December 15, the defendant summoned the incoming acting Attorney General, the incoming acting Deputy Attorney General, and others to the Oval Office to discuss allegations of election fraud. During the meeting, the Justice Department officials specifically refuted the defendant's claims about State Farm Arena, explaining to him that the activity shown on the tape co-conspirator 1 had used was benign. 28. On December 23, a day after the defendant's chief of staff personally observed the signature verification process at the Cobb County Civic Center and notified the defendant that state election officials were conducting themselves in an exemplary fashion and would find fraud if it existed, the defendant tweeted that the Georgia officials administering the signature verification process were trying to hide evidence of election fraud and were terrible people. 29. In a phone call on December 27, the defendant spoke with the acting Attorney General and acting Deputy Attorney General. During the call, the defendant again pressed the unfounded claims regarding State Farm Arena, and the two top Justice Department officials again rebutted the allegations, telling him that the Justice Department had reviewed videotape and interviewed witnesses, and had not identified any suspicious conduct. 30. On December 31, the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor. In advance of the filing, co-conspirator 2, who was advising the defendant on the lawsuit, acknowledged in an email that he and the defendant had, since signing a previous verification, been made aware that some of the allegations, and evidence proffered by the experts, has been inaccurate, and that signing a new affirmation with that knowledge, and incorporation by reference, would not be accurate. The defendant and co-conspirator 2 caused the defendant's signed verification to be filed nonetheless. To be continued, Part 3.32, Subparagraph Georgia, titled The Criminal Agreement enacts to effect the object of the conspiracy. The defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. The world is watching. The children are watching. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.